Hey there, Drew Rebar, Auditing Reno 911. Thanks for watching. I appreciate it. So today, this video is about the Nevada DMV and specifically the chief of the Nevada DMV Police, J.D. Decker. Several years ago, J.D. started working on plans to get some laws changed, and the purpose of getting the laws changed was to prevent small businesses from profiting. Why do I say that? Well, because I've got emails that show it. Anyways, this video is about a meeting between stakeholders in the industry that couldn't make as much money as they used to make because DMV wanted to change the regulations. There had never been any public complaints about any of these issues. Basically, we just have some people in the government that don't think small businesses should profit. And that's what this video is about. So you can watch what JD says as he's implementing the new laws that he got the legislature to pass to prevent profit for small business and the problems that it's created in the business industry. And any of you that live in the state of Nevada and have tried to deal with the Nevada DMV here, well, God bless you, because you got to wait months to get an appointment, get in, do anything. I think it's all by design. And well, let me know what you think. Here's the video of the new laws being implemented. Have a great day.
It's another day on the job for Chief J.D. Decker. Another day and another issue to tackle.
It's huge. We have so many shops that are unlicensed.
Unlicensed and still operating.
Good afternoon, everyone. I'm J.D. Decker. We'll go ahead and initiate the workshop for today. If you could please mute your, if you're joining us on Teams, please mute your microphones. If not, we will be able to see whose noise is bleeding through, and we'll have to mute you from here, but we won't go to the unmute condition. Okay, it is Thursday, June 29th. The time is 1:05 p.m. We will now proceed to agenda item 1 and the items for consideration for today. They call to order in the opening remarks. I am J.D. Decker. Oh, I'm sorry. We'll have to wait. The agenda there. All right, this is the time and place set for a workshop for industry stakeholders regarding the review of the passage of Assembly Bill 57 as set forth in the public notice, specifically to review pertinent elements of AB 57 as it pertains to clarifying the conduct of vehicle lien sales and ensuring process transparency. No action is being planned or taken today. This is simply an informational session to discuss how the bill's passage will affect the lien sale process and the department's interaction with the tow industry. Copies of the workshop notice and bill language have been made available for inspection and have been posted at all department facilities and at the main county library in those counties where the department does not maintain a facility. In addition, notice has also been sent to individual members of the affected business community and industry associations. At this time, I would like to request that those in attendance who wish to participate, please indicate now if you plan on providing comments to Mr. Hefner, who will note this on the signage sheets.
This is Ramin Zabedi at Nevada State Liens. I wish to make public comment.
That's fine, Mr. Zabedi. We're not at that point where we can take public comment, but we will notify you when that time is available. If you can mute your phone until then, that would be great. Thank you.
Sure.
Okay, got it. All right, moving on. My name is J.D. Decker. I am the administrator for the Compliance Enforcement Division for the Department of Motor Vehicles. I will be the moderator for today's review. Before taking comments, there are a couple points I would like to review. Number one, this is not an adversarial proceeding. This is public input on the provisions of AB 57. As stated earlier, no action is being taken as a part of this meeting or as a result of this meeting. Today's overall meeting length is scheduled for 2 hours. We will not be addressing questions regarding individual case submissions to the department. Those can be taken offline. Third, regarding public comment, for the purposes of time today, each speaker will be limited to 5 minutes to deliver their remarks. If your comments are detailed and may run longer than 5 minutes, you may want to submit your written comments to the department and they will be added in full to the record. Also, if your comments substantially mirror those previously given or submitted in writing, you are encouraged to briefly indicate that yours are the same as your written comments or the prior speaker. Next, if you do not wish to speak today but have comments on the bill, you may submit those comments in writing to the department. All written comments should be submitted to the Department of Motor Vehicles, Research and Project Management Division. Attention, Martin Hefner. Written comments should be received by close of business Friday, July 7th, 2023. The order for discussion and comment will be to alternate between those present at the conference room in Carson City and those who are attending at the Las Vegas location and those attending on telephone or by Teams. Mr. Hefner, to my right of DMV, will be monitoring those in attendance remotely and will indicate to each of those persons online when it's their turn to provide comments, and also for those of you in the room. I ask that when you are called on by Mr. Hefner to present your comments, you first state your name and the name of the business, group, or association, if any, that you represent. All right, we'll now proceed to agenda item 2, review of AB 57 and associated impacts to DMV processes.
I'd like to raise an objection. I object under NRS. I object under NRS 233B that it wasn't properly noticed. The previous record and tow car guide was not included for removal. This is obviously an agenda about enacting a new record and tow car guide, but you illegally removed the old one. You have to go through the due process to remove the old tow car guide before you get to implement the new tow car guide. Thank you.
Your objection is noticed and passed and signed into law by the governor this last legislative session was Assembly Bill 57, which clarifies existing Nevada revised statutes under Chapter 108 that an auction is required to dispose of a vehicle acquired through a lien sale. Added into Chapter 108 through the bill is the ability for a lien claimant to now sell the vehicle directly to the public if attempts to sell the vehicle through an auction are unsuccessful. The bill further clarifies that a third-party sale through any means, whether it be an auction or directly, must be an arm's length transaction and must be commercially reasonable. The department notes that this underscores the department's position that a lien claimant may not obtain title to a vehicle acquired through a lien sale if valued over the amount listed in NRS 47.270 in their own name or for anyone affiliated with the lien claimant, unless the vehicle is purchased through a winning fair market value bid at public auction. The bill also eliminates the requirement that an auction or sale be held in the place where the lien was acquired. This provision was eliminated to increase the opportunity for tow, record, and garage operators in rural areas to obtain fair market value by conducting sales in larger markets. Next item. Also passed in the bill was an increase in the trigger amount in NRS 487.270, requiring a vehicle to be sold at auction through the provisions of NRS Chapter 108. The trigger amount for the auction requirement was increased from $500, which you probably all are aware of and have been used to for the last 30 or 40 years, to $1,500, and allows additional adjustments to be set by the department through regulation and not required to be set through request from the legislature. As of July 1st, when the bill takes effect, vehicles valued under $1,500 can be titled directly into the lien claimant's name. Vehicles valued over $1,500 must comply with the auction requirements listed in NRS 108. The department anticipates this will align the legislative intent of the auction provision to vehicle values in a more realistic way and provide relief for the tow industry when it comes to the costs of auctioning low-value vehicles. The new law removes, next item. The new law removes the requirement that a vehicle towed or acquired as abandoned under the specific provisions of NRS 487.210 be titled only as salvage or non-repairable. A lien claimant may now obtain a clean title on an abandoned vehicle if certain provisions are met. Those provisions are: 1, the vehicle had a clean title prior to the tow. 2, the vehicle passes a mechanical fitness and safety inspection as outlined in 49 CFR. 3, the department approves the application and issuance of the title. And 4, the bill contains additional requirements, which I won't go over today because they only apply to licensed record, wreckers, but essentially the new law exempts licensed wreckers from providing smog certificates to third-party buyers when selling a vehicle meeting the requirements for a clean title, and allows them to sell a vehicle with minor damage to a third-party buyer. All right, next item. The law does not change the provisions of registration and does not allow for a vehicle sold to a third-party buyer directly or through auction to be registered until a title has been perfected in accordance with NRS 482.205. A third-party buyer can be eligible for a temporary move permit after the lien claimant has submitted the lien sale packet pending the processing of the title packet by the department. Next item. Passage of the bill has also entailed revisions to the record and tow guide that the department produces. This document was made available to workshop participants prior to the meeting for review. If further clarification is needed regarding any part of the guide to meeting participants and industry stakeholders, we will work to include any clarifications in the version that will be posted to our website. But at this current juncture, the tow and record guide has been reviewed, and this is part of the process of rolling it out to you all, making sure we're on the same page and answering any questions you might have. In that process, several forms that the department issues pertinent to the lien sale process are also in the process of being revised and updated. There's a list of those forms if you want them, but drafts of the documents will be prepared and available on the DMV website once we've acquired all the input that we need to update the forms. And that is the last item. We'll now begin taking comments and soliciting input from the list. If you'd like to participate in the discussion, please notify Mr. Hefter and to get on the list, and he will handle comments.
So I'm gonna go by the sign-in sheet, but I've got here several people indicated that they'd like to go ahead and offer public comment. I'm gonna go down the list here, everybody who's indicated yes. And I'm gonna alternate also between here, Las Vegas, and who we see up here that have logged in through Teams. So I'm gonna first start with Carrie Bailey. Would you like to offer testimony today or comment today?
Carl Bailey. Yes.
Carl Bailey.
Oh,
Sorry, it's underneath.
I think we put them on the same line, sorry.
Okay.
One of my first questions, what made a big question to me was, is there any law for the time that DMV has to title the vehicle for a vehicle that bought a lien sale?
I'm sorry, could you state your organization also that you're with?
Oh, I'm sorry. My name is Carl Bailey. I'm with Nevada Towing Inc. out of Reno, Nevada.
Thank you. And
Thank you.
can you clarify the question again?
The question is there any time limit or law for the time that DMV has to process a title for a lien claimant?
There's
For
not a
a lien
time.
claimant or the third party that's buying the vehicle?
There's not a time limit under law for the processing. There
Well,
are.
it's a huge problem because you're going 60, 90 days out, up to a year without processing a title. You've got them on a temporary driving it around. And I think it's kind of a corrupt deal because you're getting 2, 3, 4 smogs out of one car. That's unacceptable. That's unacceptable for anybody, and that hurts the public.
Thank you for your comments.
Okay.
Next, I'm gonna go to Las Vegas. Is anyone in Las Vegas who would like to participate in the commentary today?
Yes, this is Rabin Zabetti with Nevada State Liens. My comments are gonna be limited to the proposed modifications to NRS 108.310. So the first thing I wanted to ask is there anyone from the Office of the Attorney General on the panel here today?
No.
Okay.
And let me just clarify for you, these aren't proposed modifications. These are this is a change in law that is effective on July 1st that was reviewed and approved by the legislature. So this, as of July 1st, is law.
Well, were we noticed to file any type of objection or opposition to that proposed law?
When you say we, who do you mean when you say?
When I say we, I mean the licensees of the department or anybody who wants to object to that proposed law. When were we noticed? When was the public or the licensees noticed on that law change or given an opportunity to come and object to that law change if it's going to be in fact made law now?
So the legislative process has not changed. It did not change for the legislative session that just ended. It lasted 4 months. It's all public meetings and public knowledge, you can go on the legislative website. We indicated to industry, we indicated to your lobbyists, to the associations, and to you personally in the workshops that the language that we discussed in the workshop prior to session starting was going to be proposed in AB 57. It was proposed by the department. It was reviewed by the legislature. You had an opportunity, along with the rest of the public, to discuss your opinions with the legislature at the committee hearings, and then further, that was done. The law was passed by the legislature. It was now signed by the governor and will now become law on July 1st.
Okay, so yes or no, did the licensees or the public, were they notice of the date and time of those proceedings?
Yes.
Okay. And so when it comes to NRS 108.310, and the department confirmed via email that it received the authority of viewing versus Fahy on November 10th of 2022, and that Nevada Supreme Court opinion specifies the legislative intent that the vehicle may be sold at public auction sale and not. So now the language is saying that it must be sold at public auction sale, which is changing or going against the legislative intent of what our Supreme Court has already ruled on. And it's a shepherdized case with no, there hasn't been any impediments or any change of law or any case that supersedes Ewing versus Fahy. So I'm kind of wondering why the department took a position that violates or goes against the legislative intent or the spirit of the mechanics lien statutes. How does that benefit?
The legislative intent was just clarified and becomes effective on July 1st. This is an old argument that we've already discussed in the regulation workshops, in which you and certain other people disagree with the provisions of 108.310, and you feel that the auction language is optional, whereas the department feels that the legislative intent and the language is not optional. In the testimony that we gave to the legislature in proposing AB 57, we clarify that this language exists in law, and the intent of the legislature when passing it is the same as the intent of the clarifications we made in AB 57. The legislature agreed with us, didn't adopt your position, and so it's the department's position that the law meant what it meant prior. There was some confusion, including the what you just outlined with industries, so we clarified it through AB 57, and it continues to mean the same thing, which is that over $1,500, the auction provision is not optional. What we added was, if you go to auction, because there are times when you go to auction, you're complying with the law, you run it through auction, it doesn't sell, then what do? That's a valid concern. What do you do? So we added a provision through the law, new language in the law, that allows you to then, once you check the auction box and you've tried to sell it at auction, you can then sell it directly to a third party through an arm's length transaction and a commercially reasonable sale. What you cannot do, and what you could not do before AB 57 was passed, is skip an auction, title it in your own name, and profit off of the an underbid, let's say, prior to selling it directly to the public. Do you have any questions on that? Because I don't want to talk about Supreme Court cases. We're here to talk about AB 57. There's a lot of people that have questions.
Right, there seems to be some conflicting language because the arm's length transaction says that, it's defined that the buyer and the seller can't be affiliated. But if the lien claimant bids on the vehicle at the sale, the lien claimant would be the buyer and the seller. So that's kind of like conflicting language there.
All right, that's great. That's a great point of clarification. So there's two ways to sell it, right? Two totally different tracks. One is an auction at which you yourself could bid on it, right? It's a public auction, commercially reasonable. If the general
You
public,
cut off, I can't hear you.
it might be
Your audio's cut.
yeah, it might be your connection, but this will be recorded and available. But if you
Hello?
I can't hear him either.
Right, the audio was
How
disconnected.
about now?
You said, can you start over again?
Yeah.
Because the audio was disconnected.
Absolutely. So there's two different ways to sell it, right? One is an auction.
Yes.
If you sell it through an auction where the general public has the option to bid on a vehicle at fair market value, and you yourself want to bid on that vehicle because you want to acquire it personally or for your business or whatever, you can bid just like anybody else for that vehicle. It has to be fair market value, has to be commercially reasonable transaction, has to be arm's length, all of that stuff. And the auction guarantees that it is that, right? Because if you and I are bidding on a vehicle, the highest bidder wins, right? So there's no reason for you not to bid on a vehicle you want to acquire yourself. If it does not sell at auction though, now what do you do? Right? Because there was no provision in 108.310 for you to do anything else. So we added a provision that says you can now, because you can't sell it at auction, you tried, you can now sell it directly to a third party. Right? You're exempt from holding a dealer's license, right? Because you're able to, in order to make yourself whole as a lien claimant, you're able to sell a vehicle directly to a third party without acquiring a dealer license from the department. You can now put it on your lot, or whatever you want to hold it, sell it to the advertise and sell it to the public. What the law clarifies is you have to sell it at an arm's length transaction through a commercially reasonable sale. So hopefully that's not confusing. Basically, the department's not coming out to audit your books and make sure you got a market price for the vehicle, but we're coming out to audit the books to make sure you didn't sell it to your spouse or your kids or people at a severely discounted price. That's what we're trying to stop. You guys know that. We've been through 2 reg workshops. So this law clarifies that. You now, though, have an added method in law of selling the vehicle directly to the public. Fair market value.
Okay,
Can we just?
so the lien claimant cannot still title it in their own name or their family or their friend's name? It has to be in the company name?
No, if it's over $1,500, yes. If it's over $1,500, you now have to sell it through auction or through an arm's length transaction.
Okay.
If it's under $1,500, right, you can direct title it to yourself or your company or whatever. No, we understand it's not commercially reasonable for you to pay an auction house or to go to an auction for a vehicle that's not worth much.
Okay, and I have just one more last item, then I'll pass. As far as a commercially reasonable, I see that's not defined here in the proposed language. But there was also some authorities in Nevada that I read that were interesting, because how is a lien claimant supposed to determine the price of the bidding? We have no control over that. So when you say it has to be a commercially reasonable price, can you explain that a little bit further?
Yeah, we had language specifically in there, in the language you saw at the workshop. LCB decided it wasn't necessary because commercially reasonable to define elsewhere. But in the end, whatever it sells for at auction, as long as it isn't undercutting or interfering with the public's ability to bid, then the fair market value is whatever it sells for. If you and I bid on a vehicle and we're not colluding to lower the price of the vehicle, right? We're not making an agreement, hey, I'll bid $1, you bid $2, you'll win, and we'll get a $20,000 vehicle for $2. You understand what I'm saying? As long as we're arm's length, I don't know you, you don't know me, we're gonna bid an amount that we think is gonna win the vehicle, right? That's fair market value. Whatever it goes for is fair market value. So that's what commercially reasonable means. Commercially reasonable means you and I aren't colluding to undercut the price. We don't know each other. We're going to bid what we think is fair. Best bid takes it. That's commercially reasonable.
Okay.
All right.
Thank you for the time.
Thank you for your question.
Okay, next we're going to go to the physical location in Las Vegas of the NDOT facility. Is there anyone there at the NDOT facility in Las Vegas who wants to participate in the discussion?
I'm good.
All right. Thank you. All right, we'll go to the next person present here in person who indicated that they wanted to participate. Michael Baumbach.
I'm Michael Baumbach, president of Milling Towing, president of the Nevada State Tow Association. AB 57 goes into effect July 1st, which is a Saturday. We don't have some of the forms developed yet that are referenced in the new AB 57. What's going to be the operational parameters for us to enable the selling of a vehicle impounded for abandon that we don't have identified form for a certificate of inspection yet? So I understand that we're trying to develop that process now, but the rule is going to go into effect and we don't have a clear path forward. Do you have any instruction on that?
So that's a good question. We are, like I mentioned earlier, we are working on updating the forms. We're trying to get them out as soon as possible, while also giving you time to provide input. Some of the internal forms, like the inspection and appraisal form that my inspectors and appraisers use, will be easier to adjust. The 49 CFR form is out there. That's not a department form. I'm not sure if we're developing something specific. We are adjusting our internal forms to accommodate 49 CFR safety inspection that we don't do. That's not done by the department. And so the lien sale affidavits and applications and all that are being adjusted. I will clarify though, it was our position prior to this bill, you cannot sell the vehicle to yourself if it's over $1,500. Prior, it used to be $500.
Sure would have been nice if you'd notified the public about that. You created that December 4th of 2020 is when you created that rule, that regulation.
December
Why
4th
did-
of 2020 is almost, it's 2.5 years ago.
Yeah, that's when you,
not noticed.
no, you never notified that regulation. You never published it. You just started returning title
But you're aware of it.
Well, now I am because we found out and you hold a bunch of our titles that you're not issuing.
So you've
So I
been
mean,
aware,
you guys have promulgated illegal regulations and enforced them under the color of
so
law.
you've been aware of it since December 4th of 2020.
So you're trying to divert the topic.
No, I'm
You've
just-
been
I'm asking you a
enforcing. You've been enforcing. Yeah, I found it through your emails. You've
So
been
you've been
enforcing
notified.
regulations under the color of law without telling the public about it. That the legislation never intended. That you guys just made up inside, and you enforced under 108-26797, I believe it is, and that's the law that says the director can create regulations. So you just went in and wrote emails. Actually, JD, I've got documentation where you wrote the regulations yourself, at least according to the history of the PDFs in the Word files. So you, sir, have broken the law.
Awesome. So as I explained before, it's the department's position that prior to the passage of AB 57, the law existed that said you couldn't sell the vehicle to yourself. In fact, the majority of your industry agrees with that position and agreed during the workshops. However, just to clarify what you just stated, we did promulgate a regulation. We did notify industry since December 4th of 2020 by your.
Did you hold a small business financial impact
I
statement?
will have to ask you to leave. You get to talk, then I get to talk. That's how it works. And there are other people in here that have questions. So I'm not going to continue to debate this issue, but I will tell you, based on your own words, you've had 2.5 years of notice. We did attempt to process a regulation in which we had 2 workshops that you attended in which we told you what the language was. That exact same language, we then threw into a bill that the legislature heard, processed, approved, governor signed. We are now rolling out that language. It's hard for me to believe that you started this with, you haven't had any notice when you've had plenty of notice and you've had opportunity to discuss it with the department, with the legislature, with the governor's office. So unless you have anything else on the bill.
The part that you're missing is NRS 233B gives a strict process to do this, and that is where you failed. You did not comply with NRS 233B. That is my objection.
Okay, noted, and we're gonna move on because we're not here to talk about that. We're here to talk about AB 57. Yeah, and to answer your question, use the old forms until the new ones have been updated and published on the website.
I don't, okay, but there's not a form identified right now per the certificate of inspection for the mechanical inspection for an abandoned vehicle. Because if I hold a lien sale for a vehicle that was impounded for abandoned in the next 30 days, right? And the paperwork is again 30 days delayed. If I don't have a form to remove that salvage designation, that's gonna go on there by default, is there how do I address that?
So if you submitted a lien sale affidavit and indicate that had a clean title, that you continue to want a clean title, are you going to be able to get that 49 CFR inspection done within 30 days? You are, okay. And so that's not a inspection that we do. So I don't believe it's a form that we produce. That's whatever garage or certified inspector you go to have that inspection done is going to have a form. That's what you would submit with your lien sale packet. The department does not intend to specify or mandate that those third-party inspectors use our form for those inspections.
So is there not gonna be a reconstructed vehicle anymore then?
There still will. You can still go through that process if you want.
Is
Yes.
that using that form work for that?
Yes, it will still, yes. And so that's a good question because you'll have to indicate on the lien sale application, are you looking for a rebuild title or are you looking for clean title?
And that's a DMV form.
That is, yes, that's the lien sale application affidavit where you submit it to the department. You're telling us, hey, I'm a lien claimant. I'm conducting a lien sale. Here's the information on the vehicle. Here's the kind of title it had. Here's the kind of title I'm asking for.
Right.
And that's something you would do on a vehicle that you towed as abandoned that had a salvage title already.
Right.
And that's how we did that for years. And then after COVID, those packets got kicked too. So
Yeah.
Shady,
Yes.
can we just have a little bit of a clarification? You and I have had a lot of conversations on the definition of abandoned,
Right.
and
Yeah.
especially around kind of the squishiness with the definition of abandoned with a private property owner that, you know, our hope with 57 was both increasing the threshold from 500 to 1,500 and then really talking about what an abandoned vehicle was and what qualifies for an abandoned vehicle would help allay a lot of these issues.
Perfect. Yeah, let's do that. So I think it's NRS 47.270. Yeah. 270 describes legally what constitutes an abandoned vehicle. There's one point in time at which a vehicle may be designated abandoned, and in two situations. At one point in time is before the tow. Okay, so a lot of you guys, I know you want the short lien sale, the 15-day notice. So we've seen such scenarios where if just say it's a regular non-consent tow, but the legal owner doesn't respond to notice. We've seen some of you guys check the box abandoned so that you can get the short lien sale. The problem is that in the past is that's sent you down the salvage title only path. So, and you don't want that. So you cannot, as a tow operator, designate a vehicle as abandoned. It has to be before the tow, and it has to be by law enforcement or a private property owner who cannot reach the owner. And the private property owner has certain conditions that must be met, and there's an affidavit that they have to sign and give to you. If you get called by a private property owner and he says, hey, come get this vehicle, you want to make sure that that person has attempted to reach out to the legal owner, can find the legal owner, and will sign the affidavit that says that that vehicle is abandoned. Otherwise, you can't designate it as abandoned yourselves. Any questions on that? Because I know that abandoned means very specific things under NRS 47.270. Not checking the box later.
I do have a question on that too.
Okay.
For commercial property, when they do a sweep, and they do have generally some abandoned, some are an attractive nuisance, just illegally parked. So we try to break those down too with them, but same scenario.
So only if they have the affidavit, only if they sign the affidavit.
So they're the ones doing the affidavit, and they determine why they're towing it.
Yeah, and I'm
that's
guessing
what
your
you're saying.
question is, does the property owner have to fill out the affidavit, or can the leaseholder, the person that's leasing the property, right?
No, we make sure that it's the person that's contracted with us.
All right, so the question is,
Just, are you guys gonna consider things coming out of commercial property abandoned, or can there be other motives for that tow being requested? So
it can't.
illegally parked, no authorization to park, things
It's
like
only
that.
abandoned if
Right.
they sign the affidavit. And so, I
Okay.
mean, I think that's. I think-
And they check the box.
Yes.
Or
I think
they
that's been
write
one of the
abandoned.
issues we've had since we haven't had this tow on record guy for the last, 2 years, that there has been some kind of questions. And so hopefully, today, and I mean, I'm hopeful that we will have these conversations with law enforcement, with some of those private property owners as well.
Well, and then
So
you
that
also
will
have,
limit the number of vehicles that,
and NTA
Yeah.
gets involved in that too, because there's the 48-hour, there's the must be it must have expired registration for over 30 days.
Right.
I mean, you have a lot
Can't
of
tow
things
for
that go into that.
So it's easier for law enforcement because they can just declare whatever they believe it is, but the private property owner, like I said, has conditions that have to be met.
Okay.
But this is a good question. For us, private property owner can be, a private residence owner or a commercial property owner. It doesn't
matter,
There's no difference in the law, at least for us, as far as the lien sale goes. Again, chapter 716 under NTA there may be things that you have to comply with. But for us, the commercial property owner is a property owner for the purposes of that section.
Okay.
JD, we're gonna go to online. We've got a couple of people patiently waiting, so I'll let them go ahead and participate. We'll go ahead and I'll take first Marie Dishpine. If you want to go ahead and unmute yourself and proceed with your comments that you're ready.
Hi, my name is Marie Ditchpine with Lean Services. I have 3 questions. The first one, in the guide on page 71, you state about the validity of the lien sale. Now, I do that for shops. I put at the bottom how they can contest the validity of the lien sale. Do we have to do that now for tow companies as well?
That was a law that was passed in 2020 or 2021, I think, that allowed legal remedies for legal owners who wanted to contest the lien sale of their vehicle. That's a central services issue, and it is in the tow guide. I don't know if Central wants to talk about it, but it's not related to AB 57, so it is a little bit out of my expertise because it happens post lien sale.
Second question, on page 80, it says for the mailings, there's nothing in there to state we can use electronic signatures from the post office. Do we have to use the green cards?
No, we do not.
Okay, we can still use electronic mail.
Yes. Thank you for clarifying that. That's probably a good one for sure other people. And you said you had another one?
I do. I have one more. I have a tow company that is in Laughlin. Their nearest Nevada DMV licensed garage is 80 miles away. There's no body shop there. There's no auto repair shop there. There's 2 dealerships. How do they go about getting a certification from a shop? Can they use Arizona, or do they have to trek them all the way 80 miles away?
That is a good question. And it's not, because it's a federal inspection, the form is gonna be completed by, gonna meet the requirements of the feds. So I don't see why it would have to be a Nevada licensee that completes a federal inspection that the department would accept.
Okay.
Yeah, we'll get back to you on that one, but my inclination would be that if it meets the federal requirements, and they're licensed in the state that they're in, that it's not an issue for us.
Okay, those are my questions. Thank you.
Thank you for those.
Yes, indeed. Let's see.
I know Michael still has a number of questions, and I know I kind of interrupted him just for some clarifications.
And I can see that Lucas does too, and I don't want to skip over those.
It's okay. We can go to them, and then on the back end, I'll catch up on anything.
Okay.
If we
All right.
missed it.
Lucas, do you want to jump in?
That's okay. We can keep going.
Okay. All right.
Next person I have in person who indicated that they'd like to provide comment, Mark Zane.
Yes, sir. The comment that I had was probably under public comment, and that was just simply an objection to the agendized meeting here today, only for the fact that when you're trying to get all of the stakeholders in one room and you agendize a meeting on the same exact day as the NTA is having a general session, it makes it a little bit difficult, and it kind of creates a little bit of what appears to be bad faith. So that was the only thing that I wanted to, say it could have been a better day.
Gotcha.
So,
Thank you.
Thank you.
We'll go to our next person that's online that I see that has her hand raised. Kimberly, if you want to go ahead and unmute yourself and proceed with your comments, go ahead.
My name is Kimberly. I'm calling from Fast Home in Las Vegas, Nevada. And I wanted to go over where you guys said it's not a process limit for the DMV to process the lien package, and the customer can't get registration until the vehicle is titled. So what if it's taking you guys over 3 or 4 or 5 months to process it? Do they get a moving permit all that time until it's processed?
That's a good question. So yes, they can get a moving permit. They can renew. They can get multiple moving permits. I think they can get up to 3. In an instance where there's a problem with the lien sale packet, that's something that you can bring to the attention of the department, because we know there's a customer out there. But generally, you have 30 days to get the packet to the department. Department's going to process it. I think right now we're at 37 days or something. No, less, more.
It's longer than that. We're going to 2 and 3 small. The customers keep coming back. I need a small. DMV won't even
Yeah.
talk to them.
Month's good for 180 days.
90
Because
days.
right now, we
It's
have
only 90
customers
days.
coming complaining, saying that, they're not getting any more moving permits in. I sent the packet to you guys, but when I called, you guys are saying that you're behind and you haven't got to this certain month of processing, and our customers, they're blaming us and saying they're gonna report us because they're thinking we're not sending in their paperwork.
Yeah, they're gonna report you to us, and we know that you've sent your paperwork in, but the reality is the moving forward is good for 60 days, I think, right?
6 months.
You get up to 3 of those. So that's 180 days, that's 6 months. If there's a problem with your lead, I don't think it's taking central services long, 2 months.
2 weeks.
2 weeks, 2 weeks. 2 weeks times, so 6 weeks, okay. So, if you have those issues that you're gonna have to bring them to our attention, as one-offs. Of course, we're always constantly trying to minimize the number of days it takes. We are subject to the same things that you guys and the rest of the country has been subject to since COVID. People don't want to work. They don't want to work at home. They want to get paid more. They want to do different jobs. All of those things, we've had staffing problems, and we've talked about that before. I don't want to rehash it, but the department is trying to hire. We've had some relief in this last legislative session. We think we're going to be able to increase and improve staffing and training and processes and all that kind of stuff over the next few months. So the goal for us is to not be taking longer to process these than your third-party buyers are going to need in order to get a valid registration. Part of that is all of the stuff that we can do, staffing and streamlining and all that stuff. The other part of it is making sure that you guys are on the same page with us and we're not going back and forth on lien sale packets, arguing about what the law says or, responding to public records requests to uncover conspiracies, but that you guys are submitting the forms in the way that we need to see them, and there's communication between you and us, and that the information you give us allows our central services to process these forms. You guys understand what you can and can't do. They don't have to refer to CED. We don't have to hold it up. All of that stuff helps us to get those number of processing days down, and that's the goal. That's why we submitted the bill. That's why we're here with you guys. Is that hopefully on your end, if you know what we're looking for, we're getting from you what we're looking for. Central services is processing those in a timely manner. And
Can you tell us it's 180 days for the small because they're kicking them in 90? And
I think it's
what
not.
are you
You're
doing?
right. It's the dealers that can do. Dealers can go. I think dealers have a extra, but yeah, 90 days.
And
If you've got 3
I
times.
have one more question. We're also getting, coming from the DMV, other tow yards rejects. What's going on with that? Cause I have had to send different tow yards their rejects. So how is that gonna be fixed with the DMV with sending us the correct paperwork back? We're not getting our paperwork back. It's going to different yards and why is that?
Well, so if you're talking about processing mistakes or something that processing the from central, is that what you're talking about? Paperwork?
Yeah, you know how you guys reject our lien packets, may say something wasn't done right. We're getting other tow companies paperwork.
But didn't you
Like
say
they're
that?
sending,
Did you say that you're a lien processor?
yes, I am.
Well, if you're a lien processor, you're going to be getting packets back from multiple tow companies, right? Because you're processing work for multiple tow companies. If you
No. I'm just processing for fast towing, not for another lien company
Gotcha.
in
Okay.
another
And I
city.
think it's a.
I'm getting their paperwork. I may be getting a different tow yard, their paperwork.
All right. Well, like I said, Central's doing its best. They're trying to reduce the days. We're trying to improve accuracy. We're trying to improve staffing, training. Those are all goals. Part of why we're here. If you get a clean sale packet returned in error and it's not yours, please let us know and send it back to us because someone's out there waiting for it. So yeah, I didn't know that was a big problem. But remember, processing thousands of cases, and we've got a few people doing it, and those people get tied up with all of the other stuff that So
I mean, would it be just a quick poll, just so we kind of see who's had that as an issue?
wow. Okay. All right. Well, we'll take this offline with Central. I wasn't aware that's an issue. I'm sure
Lost
Central-
our whole lien packs. They never even come back.
Gotcha. All right. This
All
is
the
outside-
original paperwork, so now we're sending in copies.
Gotcha.
Because we don't have the originals anymore. They're gone.
Okay, all right.
And you used to have a where it came back to us, you signed, we signed it back and forth.
Right.
It's not no longer there.
Okay, I wasn't aware of that problem, but again, that's not a CED problem, it's not an AB 57 problem, so yeah, we'll make sure that Central's addresses that and get back to it at a later time. No.
Sorry.
But I appreciate, Central Services wants to know how they can improve the processes, and if that's something that's outside the scope, they'll still look at it, I promise you. Yeah. Okay, yeah.
Paul, Lucas, do you have any additional comments or?
I had some questions going back to some things we already discussed, so I'm happy to wait my turn.
Now's your turn.
Now's my turn. Okay. So my one question I had is going back to what happens July 1st. So just so I'm clear. So we basically will fill out the forms that are already available. We can include with that an affidavit that basically we produce that says that we're checking all these boxes that are in AB 57. We include the 49 CFR form. And if we do all that, the department's prepared to issue clean titles on those vehicles.
If they meet all those requirements, they had a clean title. But I would, instead of creating your own form, what I would suggest is using the existing form and writing in, where you check the box as to what kind of title you want. Write in clean title. Inspected. Yes. Write in on our forms.
Okay.
Because the changes in the forms are going to be the addition of those categories that will were created through AB 57.
And we're gonna add that into the towing record guide ultimately, right?
Yeah. It should be in there now.
And so,
No. It just says, hey, 57 passed, we're coming up with a process, what is it, page 68?
Oh, I'm sorry, you mean the forms?
Yes.
Yeah. We will add, yes, I'm sorry. We will add the forms. The narrative has been added
Yes.
in. The updated forms will be added in once we complete those, yes.
Until they're complete, do we just write that on the first page of the lien sale affidavit, or do you put it on the vehicle inspection form?
I put it on the lien sale affidavit because that's
First page.
the form that the department's, those are your instructions to the department as to.
Yeah. Perfect.
and the department, the relevant personnel are going to have that direction, so
Yes.
they'll know. Okay.
Yes.
And okay, so going back to the abandoned vehicle thing. By the way, I appreciate you guys having this workshop. This is helpful.
Mm-hmm.
You never said who you were.
For the Stakeholder Association, Lucas Fulton. Sorry. And so on the abandoned vehicle affidavit, I did want to clarify. So you're talking about property owners. We got situation with property managers. You mentioned people who have leases, things like that. So can you clarify who can execute those?
So basically the person who is the legal agent for the property. So the legal agent for the property might not be the actual person that owns that property. It might be a property manager, it might be a leaseholder, someone who's leasing a business, might be a tenant who rents a house. All those categories of people have legal agency over that property and can act therefore as the agent of the property owner. Those are people that can request. Because the law's not getting into who by definition constitute property owner. So for our purposes, if you have legal agency over that property through whatever position you hold, then
Thank you.
You can make decisions for related to that property. That's a decision.
Okay. Then my other question is on the tow and record guide itself. I just wanted to make sure. So you had your opening comments. Are we going to come back to the substance of the guide, or are we in public comment now?
No, we're still addressing the guide.
Okay.
The AB 57 bill.
So can you just tell us process how what's going to happen with the guide after this?
So the guide, well, we'll update the forms. So the updated forms will be added, but the guide, and it seems like it's relatively compared to the previous one, easy to understand, and that we kind of got some consensus. Hopefully, the guide will be published ultimately on the website and available for download and review and all of that.
Okay. And we by the end of July maybe, or what do you have a time frame?
I don't know. I think as soon as we can update the forms. And we've been going over those for the past few days and trying to get as much progress as possible.
I think that's all the questions I have.
Thank you. Thank you for the question. Michael, did you have more?
I do. Kind of unrelated, but it would be nice if after a lien sale auction, if a tow carrier could issue a moving permit for a 60-day period that you have to prevent extra trips to the DMV. You mentioned that DMV has staffing issues. Well, why not allow a tow carrier to help ease some of those issues? If you give us some of these requirements, we could sign an affidavit too, looking at the documents that DMV requests and then set issue a moving permit. That would be a benefit to the public because they don't have to deal with DMV until they have their smog check done, and it should save time. Just a thought I had just sitting here.
Sorry, Michael, before you go on, let me address them one at a time, otherwise I'll lose track.
Okay.
But that brings up a good point. The department has or is about to offer moving permits online. So theoretically, you can issue one by going onto the DMV website, filling in the customer's info and paying $1 and printing it off. Theoretically, that's, if we haven't already gone online.
It's online.
It's online, so.
On a lien sale?
On any vehicle, as long
I'm
as
a
you guys.
licensed dealer and we issue DRSs, we issue permits, but on a lease sale, we haven't been able to.
You can now go online, or the customer can in your office, or they can at home, they can go on their phone. But you go on the DMV website now,
Okay.
and you can, for $1, you can download a moving permit.
And that's a 30-day, right?
I think it's a 30-day, yes.
Okay, we haven't tried it, but I wondered.
Why
about
was
that.
there no 233B process when that happened?
We've already discussed it, we're not gonna discuss.
No, I'm just asking, why
I know
wasn't
you're
there
just
a
asking, I'm
process?
just answering, that's outside the scope of this workshop, and we won't be discussing it, thank you.
I have a question about an abandoned vehicle, as well. There's a form VP 262, which is an abandoned.
Quite a while.
Sorry,
Go ahead.
Bruce Sanfilippo from Quality Towing in Las Vegas. So in AB 57, have you guys changed the definition of abandoned vehicles?
that's a good question. No, we have not. What we are trying to do today was clarify for you guys what abandoned meant, because one of the things that we see in mass on our side that holds up the process is a box checked by the tow operator as abandoned without the law enforcement ordered tow or the private property affidavit. In order for you, some of you know that will get you the 15-day notice, that what we call the short lien sale, but that vehicle is not actually abandoned. And in the past, that has limited the vehicle that you're talking about to a salvage title. So we didn't change the definition, but we're using this opportunity to clarify the definition because it's key to streamlining the submission that you guys make and our ability to process those quickly.
JD, is that something we could put out in the process?
At this point,
That out in the
if I wanted to follow the letter of the law as it's written in NRS 487.210, I would be okay and fine. That's the definition of abandoned vehicle. Is that correct?
Absolutely, yes.
Okay, the second question, have you guys changed the definition of a salvage vehicle?
No, we have not.
No change at all,
Nope. No change.
from RS 487.770.
No, we have not changed.
Third question, so if I'm parked at a facility, whether it's on the street or somebody's property, and somebody says, that thing's been here for 30 days, it must be abandoned, get it out of here. And automatically, arbitrarily, you guys say, okay, it's abandoned, he gets a salvage title.
Mhm.
And let's call it
Well,
a
hang on. Well, let me stop you. We don't say it's abandoned or not. We have no idea to know if it's abandoned. You guys say. You guys tell us. Because I'm not there in central. There's no one from DMV there when the property owner meets with you or talks to you, or law enforcement. You get an auto return call. We're not there. So if you tell us it's abandoned, then you got to send in the law enforcement, the tow sheet, the impound sheet, or the private property owner.
So,
Sorry, go
so
ahead.
my question is, so if the property owner or property manager or law enforcement put abandoned on the tow ticket, does that automatically make it abandoned vehicle?
Yes.
Okay, so that being said, at that point, does it not get a salvage title?
That is a good question. Prior to July 1st, yes. But one of the changes that we made in AB 57 was that if it had a clean title and you as the lien claimant want to maintain a clean title, you can go get it inspected, submit the proper documentation, and you can come out of it with a clean title.
So there is a mechanism to go from a salvage title to a clean title in Nevada?
No, yes, well, yes, no.
No.
There's a mechanism for you as a lien claimant to go from clean title to clean title on an abandoned vehicle. That's one route. There's the opportunity to go from salvage title to rebuild title, and everybody else has that opportunity. Those are the two things you can do.
So how do I go from salvage title or rebuilt title to clean title?
You cannot.
Oh, so that's my question, that you're answering for me. So if my car gets towed and it gets a salvage title, let's call it a 2022 BMW, and I happen to be in the hospital, and whatever the BS is, I come out and my 2020 BMW is now got a salvage title, and I can't sell it for but half of what I normally do. I'm gonna come after the DMV.
No.
I mean, I don't think it's right to do that.
So is it possible there's confusion between the definition of salvage and this process that we've just described in AB 57, which avoids the salvage title being issued in the first place?
I think there must be confusion because but you said if my BMW has a salvage title, how did it get a salvage title?
It's abandoned.
It's abandoned.
It's abandoned.
So the towed is abandoned, and and Bruce, you've got it, right?
Yes.
And the lien claimant, the legal owner doesn't respond to notice, right?
Well, if the property owner or law enforcement says abandoned, which they automatically say, does that make it an abandoned vehicle?
Well, it depends on the situation. So I'm trying to explain it to you, though. I don't know your situation. It doesn't get a salvage title just because you've towed it as abandoned. You still have to apply as a lien claimant for a new title. It could sit on your lot for the rest of its life, and in the year 2100, it can still have a clean title and it's never moved. The title doesn't change until you apply to us for a new title. So I have to know, are you a lien claimant? Are you applying for a new title through a lien sale? And if it had a clean title prior to your tow as abandoned, and you want a clean title from us in your name, and you get it inspected in accordance with the 49 CFR, yes, you can still get a clean title. That's the change in the law. That's one of the changes in the law that I mentioned. Does that answer your question?
I think it does. I think it does.
All right.
And so my other question is that we get proper inspection to determine they're not damaged or unsafe or whatever the case is. So is the DMV going to do the inspections for us?
We do not. We do not do federal safety inspections. That's something that a licensed shop, repair shop will have to do for you. We don't do those inspections.
Thank you.
Thank you.
Just for clarification, I do think it's very appropriate for DMV to communicate the definition of abandoned to folks. Because I know, once again, there is a tremendous amount of confusion. And you and I went, I think, 2 days trying to, get to a point on this. But I do think a memo from DMV to the regulated entities, we can put it out there to the Apartment Owners Association, just so there's that understanding that unless they have signed an affidavit as a private property owner, that vehicle should not be marked as abandoned, because Bruce is 100% right. You don't want, just because somebody checked a box, right, to half the value of the vehicle, and hey, that's if the tow operator doesn't want to pay for that inspection. So
I get what you're saying, but there's three parties. There's the property owner, let's say, that's requesting the tow operator, and there's DMV employee. Two of those parties are at the scene when the vehicle gets towed and can interact. One of them is not. We're not there. We know what you tell us. I would suggest that, we can post it on our website. We can put it in the tow record guide. But the reality is, we want you guys to understand what the definition is. We want you to be the experts. So when you're out there with the Las Vegas marshal who's requesting the tow, or the property owner that's saying, I think this vehicle's abandoned, you can explain to them, did you make an attempt to contact the property owner? Because you probably, you got to. So,
and there's some requirements in how they do that.
There is some. And
so if they haven't fulfilled any requirements,
right,
and that vehicle wants to be towed, it's not abandoned and we don't have to jump through the salvage
Yes.
hoops.
So I would say it behooves you guys to know and educate whoever's requesting the tow. Because that's the one point in time at which you want to get it right.
The definition of abandonment is already there, it hasn't been changed according to. And so we already have the NRS definition, and we already have the NRS definition of title. What was salvage vehicle. And so if we follow those, then we should negate a lot of this problem with the 100 and something salvage title that send you guys back.
That is,
Right.
yeah, that is absolutely true, Bruce. I appreciate you stating that way. And the third prong of that is, if you follow the auction provisions, which should be easier now that we bumped that auction requirement up to 1,500, then we all really have, then we're all at 100%. Then we got no problem. Central can process these in record time. We lower the time. So thank you for mentioning. Those are the three things, Bruce. Absolutely. Yeah.
And
I just wanted to say that I stepped into this, I don't know when the last meeting was, a year ago or so, in November. And now I've had this meeting, and to be honest with you, I had a chip on my shoulder about you and Julie Butler. I felt like you people were coming after me, and I want to say thank you very much. You've straightened me out. You've done a good job. And I've completely turned around and feel like you're helping us, not hurting us.
I appreciate that. 100%.
Thank you for that.
Thank you for mentioning that. I really appreciate it. Thank you.
We're gonna go to the next person online that's been waiting patiently. Chuck, if you want to go ahead and unmute yourself, go ahead and proceed with your comments. Thank you.
Yeah, DMV Services. How you doing today?
Good. Chuck, before you proceed, I'm sorry, and everybody else who's not talking that I see that's on Teams, just go ahead and make sure you're muted, so that way everybody can talk unimpeded. Thank you very much. Chuck, go ahead and proceed.
Yeah, a couple of things. I don't really do tow liens. I do the liens for the garages, the body shops, and the dealerships. A lot of this stuff that you guys are talking about is for towing. When you do a garage or a body shop, it's a secure transaction. There is no threshold under 500, under 1,500. How are we going to proceed with those? Because we've had a couple of our liens that we have done. We've had compliance enforcement go to these shops, and they're telling them two different things. They said, first they say, well, you could, if you're buying it back yourself, you can use what is owed on the car. Or you got to get rid of your storage, and you can only use your repairs. So because they don't fall under towing, they're a secure transaction.
So the answer.
So how are we doing that?
That's a good question. I promise you, no one from CED said you could label fake the market value of the vehicle as the cost of your owed lien. I promise you didn't say that. The fair market value of the car is the fair market value of the car, and if you can't determine it, you can get it appraised. You can just put it up in auction, and it'll sell for what it sells for. There's your fair market value. What you cannot do, whether you're a garage, body shop, dealer, co-operator, wrecker, if it's over $1,500 market value, you cannot sell it to yourself by bypassing an auction. You cannot also knowingly undervalue the vehicle on the lien sale affidavit in order to then keep the vehicle under $1,500 to avoid the auction and trick the department into titling it in your name. There's no difference between tow operators and body shop and anybody else. The provisions of the $1,500 cap trigger, let's call it trigger, are as to whether you can title it in your own name if it's under $1,500 or whether you have to go to auction if it's over $1,500. And there is no difference. Does that answer your question?
That answers one.
Okay.
The other one is the VIN inspections. Are they still letting the actively licensed garages, body shops, and dealerships do their own VIN inspections?
Yes, that's outside the scope of this, but to answer your question, yes, you can register with the department and be certified to conduct VIN inspections, yes.
Okay. See, I'm confused because you guys actually had your CD officer come in and actually say that to this guy. Okay. So I understand you're saying that he didn't do it, but he did.
Okay,
He
but
told me.
well, I'm not gonna debate that with you. If you say he did, I believe you. But what I'm telling you here today is what we're going with, okay?
Okay,
Thank you. All right.
that's why I'm confused, because your compliance enforcement officers keep saying things different
My
than what
information
you
is
guys are actually trying to put into this bill.
my information is published. It's on the website. You can email me if you have questions and you think you're hearing it wrong from one of my employees. Feel free to reach out to me.
Okay.
Thank you.
Hello?
We have
Hello?
one in there.
Yes.
Yes.
Hi, my name is Camilla and I'm with Quality Time, the URT brand of companies. And I have a couple of questions regarding, one of them is not in effect at this meeting, but because so many of the Nevada Department of Motor Vehicle clerks here in Southern Nevada are taking, when we sell the car name, they get that lien registration paper to go over to get the permit. They're turning them away. They're telling them you cannot get a permit because it's a salvage vehicle. Who do we address that concerns with? Who do we need to talk to so that can be corrected in the department?
Yeah, so that brings up a good point, which is related to the last comment, which is, this is there's complex law around it. There's complex policies. Not every technician, not every CED officer gets it right. We want to get it right. We're trying to educate our people. We're trying to establish a baseline for the law. We're trying to make sure we're on the same page with you. But that happens. It happens when you go to renew your driver's license. Sometimes you get bad information from a tech. Ask for a supervisor, or ask for their supervisor, or email central services, whoever your contact is, or email CED. But I can't tell you, and I don't think anybody expects for 1,800 DMV employees to do everything perfect every time. People make mistakes. We want to fix those mistakes, though. You just got to tell us about them. I promise you, no one's doing it on purpose to ruin your day. This is not an easy subject. We've all, and when I say we, I mean the people in this room have been talking about this for 2.5 years, trying to figure it out. So I think we made a lot of progress, but please let us know if you think something happened or if you're told something.
We have a specific case where the person went over to get that permit. She was denied. She parked it on a residential property or apartment complex. It was towed by another tow company. And the bill ran up. She couldn't get the vehicle out because the lien sale paperwork was still in progress. So that it is a problem. Not saying that you should fix that issue at this present moment, but it's something to be considered if the clerks don't have the proper information. And like you say, I understand everybody's not going to get it right as far as employees go, but that should be something that needs to be put on the front burner. Some people aren't getting these cars that they just purchased from a lien sale auction. So moving on, my second question is, when you address you can go online and get that movement permit. Isn't there a verification process of insurance and other things that you have to do?
Yeah.
And just a test that you have that insurance.
Yeah, you got no exemption there. I'm sorry, but no one gets an exemption for having insurance on the road. No car is going on.
Online to print a 30-day or 60-day permit. Are we required to do something? Or is that person required to do something?
I'm not sure I understand the question.
Okay, let me rephrase it. I go buy my car, I go to the DMV, I go on the computer and I want to print out a permit. Or the tow company wants to print out a permit online, movement permit on my behalf. Do I have to verify insurance or anything to that nature to get that permit?
Absolutely. Yes. Absolutely. There is no way the department is giving out a permit to drive your vehicle on the road if you don't have insurance. I'm sorry if anybody thought that was different, but I think we're in a position in this modern day and age where I hope is not anybody out there that thinks they have an exemption from driving a vehicle on the road without insurance. That is absolutely not the case in any scenario.
The next question, the CFR 49, is that in safety under that particular code, that form that we need to submit for the mechanical, but the exemption to the salvage type?
Yeah, and that brings up a good point. So for anybody who doesn't know, CFR means Code of Federal Regulations. It's the federal law, basically. CFR 49 relates to vehicle safety, traffic safety, all those kinds of things. That is to answer your question, yes, the form or the inspection and the form that goes along with it is related to the safety condition of the vehicle in relation to federal regulations in 49 CFR. The state doesn't have those kinds of things yet. Great, thank you. Anything else?
That's it.
Okay, thank you.
Something that you haven't gone over at all. Maybe?
As far as the abandoned vehicle and the definition of the abandoned vehicle, in different counties, I don't know how it is in Washoe County or Carson City. Here in Nevada, there's a definition for that under our municipal code. And it simply says that it has so many definitions, but it's just not in you guys' statutes. It is in some of the codes here in Clark County.
Yeah, so just so we're clear, I realize what you're saying, and there are some different laws that municipalities have. Those laws do not have any jurisdiction over lien sales. So for our purposes, for the purposes of having the department process a lien sale, the only jurisdiction we have and the only statutes that we will recognize are the ones related to 47-270 when it comes to abandoned. The municipal codes will relate to where those vehicles can park, where they must be towed, who can tow them, all those kinds of things that you guys, I'm not saying you don't have to comply with. Just like 706 has some differences in the language. But 47-270 is the abandoned statute that we comply with in order to process a lien sale.
Okay, I understand that. The thing is that when you're going back, and I know you're gonna be looking at the definition probably, and putting something out there for us to have at least a guideline to go by. When it comes to the county, probably need to understand too how it relates, because when you have your law enforcement, is in the county code, to write that on an impound marker, non-consent impound marker, then that's gonna be up there as a title, and because it's that way, should we have to go through all the steps of doing the vehicle inspection and the application for the clean title?
So I'm not sure I understand your question, but you never have to go through the steps. You don't, if you're okay with a department issuing a salvage title, you don't have to get an inspection. So this is a new thing in the law which allows you to obtain a clean title on an abandoned vehicle, which previously the law prohibited. We added this to the law, so now if you want to get a clean title on a vehicle that had a clean title for the abandoned tow, you can get an inspection and get one, but you don't have to. Is that what you were asking?
I understand exactly what you're telling me, but I believe because most of our abandons can be prevented as far as non-consent from personal private property HOAs. But when it comes to law enforcement, we have very little control of what they consider to be an abandoned vehicle. It could be that I went to a bar, I got drunk, I got arrested, and my car sat there until I got up, and when I got up, jail, it was gone. That technically to me is not an abandoned vehicle.
I get you. Okay, I get where you're going. So I will tell you that is a good point. We don't have a ton of those, but we do have scenarios where, based on county or municipal codes, a law enforcement agency will request a non-consent tow. They'll label it abandoned in violation of their own municipal code. You guys get the vehicle. You don't want to process it as abandoned. What do you do? Because sometimes you've gone back to the agency and said, hey, this is an error. Can you change it? And the agency has said no. If you get those scenarios, because they're one-offs, let Central know. Central will send it to us. When I say us, I mean CED, Compliance Enforcement Division, and we will reach out to that law enforcement agency, we'll review the codes, and we can make a determination as to whether, if that was labeled abandoned in error and the agency refuses to change it, my staff can change it if it meets the law. Does that help?
That helps a lot.
Okay, thank you for the question.
2 questions, real fast, hopefully. We haven't ever touched this yet, but the bottom line is, I repair a lot of the vehicles that are broken. So the vehicle comes in, the transmission's bad, body's perfect, glass, interior, nice car. Broke down on the freeway. Cops had us towed in, it's not barked up, it's not abandoned. You know, it's a nice car. It's probably worth $5,000 or $6,000. I get it in. What's wrong with it? It blew its engine, maybe. So I put an engine in it, fix it, put it out there and sell it. I gotta be, it's a regular title, still a lien sale.
Right.
I gotta be a licensed repair shop by DMV in order to put that engine in,
You do. Yes.
even though I own the car,
Yes.
basically, because you're saying I don't own the car.
So here's the thing.
Cleared lien. I
Yeah,
don't own the car.
You're getting into some gray areas, but I get what you're saying. So if you acquired it professionally based on your tow license, if it's under $1,500 value,
I know that it's salvage.
yeah, and you lien sell it to yourself, theoretically, because what we don't want is you blurring the lines between personal hobby or profit with your business. And the thing is, if you're an individual and you just like acquiring cars and repairing them and then selling them, you can do up to 3 a year before you need a dealer license.
Oh, I have a dealer's license.
You do. Okay.
Yes, I do.
Well, so then then you're licensed to tow it.
Licensed to
You're
tow.
licensed to sell it.
Yes.
You gotta be licensed to repair it.
Well, I have a full auto repair shop and I have a full body shop and I'm fixing my own cars. I'm not open to the public.
Yeah.
A guy doesn't drive in for me to have a license say I can repair your car. I'm fixing a car that I already own, and that's in my opinion. I granted it's a lien sale, but the owner of that car previous that I got it from, he never shows up. There's a bank, legal owner. They never show up.
Yeah.
And whatever process, they say we got the paper out, one paper late, doesn't make any difference. We reduced it by that. You guys are getting involved in that. But the fact is, this car was never going anywhere. No one's going to buy it $200 or $300. It doesn't run, it doesn't move.
Yeah.
I fix it, now it's worth $5,000.
Right. I say we should probably address that offline so that it doesn't, because it doesn't quite fit into what we're doing. But I
Okay.
understand what you're saying. There's
Same with the body shop. I put fenders on, headlights, grills, nothing wrong with the tires, and it drives beautifully
Yeah.
with the fender and the headlight. But
Yeah.
I got to have a body shop license now in order to put a fender on.
Yeah. We'll talk.
I'm not open to the public.
We'll take that one offline. Yeah.
Okay.
Yeah. I
Thank you, sir.
I understand what you're saying. Yeah.
One last person.
Could I give my question answered on the VP 262 form? That particular form, there's not a whole lot of information on it, but from my understanding is if a tow yard or a tow operator tows that vehicle to a garage can store there, and the lien basically transfers from the tow car operator to the garage or body shop. Now, my question related to that is NRS 487.270 requires an appraisal to determine whether it's under $500 or over $500 to determine whether you're doing a short lien or a long lien. So the DMV appraisal section has refused to come and do that for garages and body shops. They say they only do it for tow yards and wreckers. So how do we complete this process under the VP 262 if they're refusing to appraise it?
This is something we should take offline.
Yeah,
I think Rowan, if you can call us later, I know you know how to get hold of me, and we'll talk about this offline because I think it's a little bit outside the scope of the workshop.
When you say offline, just shoot an email to Mr. Hefner.
Sure, that's fine. Yeah.
Okay.
All right. Thank you.
Jay, we got one last person here before we get to the rest of the online people.
I'd like to get on the agenda, please, too.
All right. And Chris Holland, you'd indicated maybe a comment?
Okay, my question has been answered.
Okay, I'm gonna go take the next person here online and then we'll go ahead and let you go ahead and speak. Diane at GF Auto Group, you've been waiting. You can go ahead and unmute yourself and present your comments. Thank you.
Hello, I have 4 questions. For the more than $1,500, if no one wants the vehicle, let's say I just cannot get rid of it in auction. I can't get rid of it through anybody, just how would we maybe be able to post it online and sell with no title? If, let's say someone in California says, hey, I want to buy it, or I want to buy a couple of cars that are just, I don't want to use the word junk because I don't want to junk the title, but what would I do, or how would I move forward to get a title if I don't have a buyer on the other side? Per se, I guess.
Yeah.
I mean,
Right, I see what you're saying. So it's over 1,500. You can't title it on your own name. Can't sell it at auction. You haven't been able to sell it directly to the public. But I would say that you sell it the same way you would if you did have a buyer from the public. It's still a lien sale with a titling process through the department based on your position as the lien claimant. So you still have to sell it to a third party. You're not gonna have a clean title. You're never gonna have a clean title when you sell these, basically. Unless it's under 1,500 and you've titled it in your own name, but everything over 1,500, even when you take it to auction and you sell it, let's say you let a third party auction sell it to the public, it's the same situation where you don't have a clean title. At that point, you've got your lien sale affidavit and your lien sale packet that you're providing to the buyer.
The new buyer.
Yeah.
Okay.
Does that make sense?
Yeah, so, with that being said, we are a body shop, we are a dealership. Previously, we were able to purchase it or even at an auction, nobody showed up, we would go ahead and sell it over to the dealership. We have a lot of colleagues that are dealerships, so same thing, they would come to the auction and whoever didn't buy it, then, okay, hey, I'll buy it for you, for $3,000, $4,000. Now that's not the case where body shop and dealer under the same principle is allowed. Is that correct?
If it's arm's length, if it's not your you can't sell it from your body shop to your dealership. Is that what you're saying?
Correct.
Yeah, no, you can't do that. You're still the principal of both of those entities, right?
Correct.
Yeah, you can't do that. It's gotta be arm's length and commercially reasonable.
Okay, so if, let's say I'm ABC Motors and I'm selling it to XYZ, they have to pay taxes up front, or they would, because that was one of the questions from one of the cars that we had is I was trying to sell it and the dealer's like, well, I'm a dealer. I don't pay taxes. I said, well, the state says you gotta pay taxes. Well, I don't pay taxes. So we're going back and forth, back and forth. I do not have a concrete answer to say, yes, you don't pay and then you'll pay at the end, or.
That's a good question. So let me just go back to your first question and just add that your dealership or your body shop can buy that vehicle at auction. So just don't forget that. If you want to sell it from one to the other, remember you can still do that. But I don't think you guys are collecting sales tax.
Wait, I'm sorry. What, can you repeat that again?
Well, you were asking if your body shop could sell it to your dealer, and I said no, right? Because it's not arm's length.
Right.
But you can still, whoever the lien claimant is, whichever one of those entities, you can put it up for auction and bid on it through any one of those entities, as long as it's as long as it's an auction that's fair and you're not undercutting.
Okay. Right.
I just want to close the door on that scenario without mentioning that, because Paul mentioned. So I don't think you guys are collecting sales tax on the sale of a vehicle to a third party buyer, are you?
Yes.
You are.
Yes.
You are. Okay.
But I can answer her question
Okay.
because if you stamp or if the party that you're selling it to has a Nevada resale permit, they just stamp their resale permit into where sales tax is on the form.
Right.
And I've never had DMV kip one.
Right. Now, remember, we're collecting tax not on our behalf, but for taxation. So I think what you're doing at that point is
We're notifying you.
that you transfer the tax liability onto a different.
And they'll collect the tax when they sell it.
Yes.
Mhm.
Yes. Does that answer your question? Thank you.
Another alternative is you could just put 0 on the sales price. That way there's no tax liability and it transfers into the dealership's name.
Well, you have to put accurate information on those forms or we're coming after you. You cannot lie on those forms. Let me remind you that it is a gross misdemeanor to lie on a form and submit it to the department. That is a criminal penalty, a criminal charge. Please do not lie on our forms.
Well, that wouldn't be a lie. Generally nobody shows up to these auctions. So if there's nobody there to bid on it and you put a $0 amount to go into the dealership's name, then how is that inappropriate?
She's talking about transferring it to a different dealer.
Yeah. Or her own dealership as well, the lien claimant. The lien claimant has the option to bid at auction sales, from what you guys have been saying. So if nobody shows up to the auction, then that's commercially reasonable because you gave notice to everybody, you published it once a week for 3 weeks. If nobody shows up and you basically retain the title. I mean, I don't know what number is appropriate to put in there, but basically the lien claimant's retaining the title.
I think we're misunderstanding, but she's talking about selling the vehicle to a third party, a dealer. another dealer who's gonna then sell it to the public, in that case, you would transfer liability on the second retailer. If you don't sell a vehicle at auction, I don't know what form you're talking about, because at that point, you now can sell it directly to the public. So you're not putting it on anything on any form at that point, but do not put the value at zero if the fair market value of the vehicle is more than zero, please. So.
I need more clarification on that response, because the amount that we put in there for the sales price of an auction vehicle, I mean, because I want to make sure that we're doing everything correctly.
He's talking about selling it to himself.
Yeah, you're talking about
He
selling it
doesn't
to yourself, and that's not what we're talking about, and that, you cannot do that.
Can't do that.
No, if you bid on it at an auction sale, I mean, you're not allowed to do that?
No, you can bid on it at an auction sale, but you're not gonna, if you're gonna tell us after you bid on it, winning bid at auction sale that it costs you $0, then it's going to my group and we're coming after you. You cannot do that.
Right, if nobody shows up to the auction sale, then how do you bid more than zero on it?
Okay, if it doesn't sell at auction, okay, it's two things. Commercially reasonable, remember commercially reasonable?
Right.
I'll tell you what, if that's what you wanna do, we can talk about this offline, because I promise we'll talk about it offline. Coming out to your office.
Yeah.
But do not lie on our forums. End of story. In any scenario, I don't care what scenario, don't come up with another scenario, I don't wanna talk about it. If you wanna submit that, we'll come out. Do not falsify a DMV form, it's a gross misdemeanor, and we will charge you criminally.
Right, I'm offended by that. Nobody's falsifying anything. We're just, getting clarification because you guys are all over the place with everything. So I'm just trying to narrow it down.
Yeah, but the fair market value of the vehicle is you're gonna put zero on a form, is what you said. Can I get back to Diane, because I think we're just going down a rabbit hole. I don't wanna argue with you, I don't understand what you're asking me, I guess, so can we go to the next question?
Okay, my next question is for permits online, while you guys were talking about it, I went onto the website, I was pretty much surfing and the rules for getting a permit online, the vehicle has to be, you can't get a permit online, so maybe that is something that is not available as of now. You can get a permit if the vehicle was registered to you, if it had a Nevada registration that is active, less than 18 months ago. It says permits are issued to the registered owner. So in this case, it would not be the registered owner yet because you're not allowing the owner to register. So, how would we go about assisting the customer in getting a permit without making a 2-month appointment at DMV? And now they're driving around with no registration, no permits. They have insurance. I have one right now. He has insurance, he has a smog, DMV told him no registration, and he's had 2 months of, 2 permits, so 30 days each, and he's driving no registration. He has insurance, has a smog.
Well, I thought you were asking me how to get a permit, but you said he's had 2 permits, so I'm not sure what the question is. But I don't.
No, my question is, so online you cannot get a permit. Is that something coming up soon?
You can get a permit.
I haven't.
You can currently get a permit online.
You can, but it tells you online, the vehicle must have a Nevada registration that is active or expired. Permits are only issued to the registered owner. How is it registered owner if you're not allowing him to register?
And those are questions I can't answer, so we're gonna have to get back to you guys on that. We'll get back to you through your, so again, these are field service process, these are not CEs.
Okay.
So I don't know, but I'm looking at my people in the back and they're saying that, this is probably something we need to take offline, because I don't know the answer, to be honest with you.
Okay,
There's field
and my last question is, are you bringing the expedited processing back? Is it never coming back? Do we know why it was taken away?
We have expedited processing, I believe.
Not for lien
Not for
sales.
lien sales, we don't. Okay, we don't. I'll tell you why we don't. Because the lien sale has to be processed to the satisfaction of the department. Let me be very clear. A lien sale is a seizure of someone else's property. A private party, you, are seizing property from a legal owner using the authority of the department as a government entity. So we want to make sure that we're not violating anybody's Fourth Amendment rights by allowing you to take their property without thoroughly reviewing the packet and the reason and the documentation, and that we can validate that you have the legal right to do it. So the idea that we can somehow offer you a service that expedites that process over the rest. It really makes sense. We're trying to do all of your lien sale processes as fast as we can while checking all the boxes and making sure that they're all legit. So this was a department decision, I think it was over a year ago, to stop offering expedited because we didn't, number one, have the staff to do it. So we don't want to charge you for something that we can't produce and give to you. And then the reality is a lien sale is a big deal. It's a seizure of property. We don't want to rush through it. We want to do it as fast as we can while making sure we get it right. So that's why we don't do it anymore. Anybody who fudges the documents or maybe, checks the box wrong or selling it to themselves illegally or is fudging the numbers is going to ask for an expedited hoping that we make a mistake. That makes no sense from a department perspective and from an industry's perspective to offer to you guys or your competitors. So that's why I wanted.
Okay. Okay, thank you.
Thank you.
Yeah. Just letting everybody know, we're at the half-hour mark before our meeting is scheduled to conclude. I know that we still have many people who would like to make their comments, but we still have to get to the rest of the agenda and allow for public comment before we can wrap things up. So I just want to like to say to everybody, if you can, we'll try and get to as many people as we can that are still online and here in the room. But if you can make your comments brief so we can allow everybody at least a chance to participate in the discussion and then hit all of our agenda points, that would be great. Thank you. So the next one we're going to go into, Mr. Rebar, I think you indicated you wanted to comment.
Good afternoon. My name is Drew Rebar, A&A Towing. I'll try to keep my questions fairly short and yes or no answers, hopefully. Just to clarify, is this an NRS 233B workshop meeting to adopt regulations?
No.
No, it is not. You stated that we're working on the record.
I'm sorry, do you have any comments regarding AB
No,
57 or the
you
tow
work-
industry?
Could you
That's
please
it.
not interrupt me?
No, but I have, we have.
I'm getting,
Excuse me.
I'm talking about the wrecker and tow car guide. Is that on the agenda?
Yes, it is.
Okay,
You
so
can keep
the
comments
wrecker and
brief.
tow car guide, is that a regulation?
Excuse me.
Is the wrecker and tow car guide a regulation? Yes or no?
No.
The wrecker and tow car guide is not a regulation. NRS 233B 038 states a regulation defined. A regulation means an agency rule, a standard, a directive, or statement of general applicability which effectuates or interprets law or policy or describes their organization, procedure, or practice requirements. Does the wrecker and tow car guide meet that definition?
The wrecker and tow. Look,
Does the wrecker and tow car guide meet the definition under NRS 233B 038?
I'm going to ask you to leave, and I'm going to suspend the meeting until I'm able to talk. This is a workshop that I'm running. This is not an interrogation for your purposes. If you have questions related to the subject of the AB 57 or the tow and record guide, we will entertain those.
Okay.
If not, this is not the opportunity for you to lodge your objections.
It's not objection, just a simple
Stop,
question, yes or no?
Excuse me, stop interrupting me. To log your objections to the substance of a bill that was passed by the legislature and signed by the governor. Do you have any questions related to the tow and record guide or the subject of AB 57?
Yes. Can you describe exactly what is a third party?
No, that is outside the scope.
No, a third party is in the NRS. You're requiring a third, hang on, you're requiring a third party in the NRS and you're telling me you won't define what a third party
Do you
is?
have any other questions?
Why won't you define what the AB
Does
57
anybody else
is?
have any other questions?
No, I'm not done with my questions about AB 57. I object.
Sir, I'm running the meeting.
I object. You won't answer my
It's time
questions.
to go to someone else with another question. That means that's what we're going to do.
So you won't answer the
Please
questions.
suspend your comments for now. Yes, go ahead.
Next up, we'll take Diane and Jose. They've indicated that they want to participate. Please go ahead and unmute yourself and proceed with your comments. Oh,
Jose, if you're speaking, we cannot hear you.
you might still be.
Oh, I wonder if he's.
Thanks. Thank you. No, he's not there. I don't know. You're clear from our end. Can you hear us? I can see you. Let me try something.
See him doing these things.
I'm gonna make an assumption here that some of the comments I have is.
Yeah. Jose, can you hear us? You can send an email. You can send your question in an email to Mr. Hefner. Yeah, sorry, we can't hear you. Okay. All right. Is that it?
No, we have one more. Marie Dishbein has a follow-up question. Marie, if you want to go ahead and unmute yourself and go ahead and proceed.
Okay, I forgot to ask about one question. On VP 213, that's the allocation for salvage title. If we have to get a salvage title on these cars that are abandoned, they don't really fall under the total loss or the flood. So what do we mark, and is there a way to make a box on there that says abandoned for the salvage vehicles?
You know what? I will tell you what this one is. This is a question for Central Services. I will add VP 213 to the list of forms that we're reviewing.
Okay.
Because if it's not currently, it doesn't suffice in order to incorporate the changes in AB 57, then that's one that we need to look at.
Yeah, if you could, I would appreciate it, because it's hard to mark something if it's not true.
Thank you.
Thank you.
That appears to me that everyone else has indicated that they like to speak. Do you have a follow-up question?
Yeah, I'd like to speak. I've been interrupted twice now.
Sure.
For public comments.
Go ahead.
I'd like to finish if I'm next. I
Yes,
appreciate it.
please.
Again, Michael Bombach, President Millington. We've discussed a lot about the definition of the word abandoned, and since we have so many jurisdictions, we have to communicate that definition too. I think it'd be imperative to include the DMV's definition of abandoned in the tow and record guide. That way we can use the published guide when we talk to law enforcement agencies, so we're all reading from the same script, if you will. I think it'd be very important for us to help the processing, because law enforcement doesn't honestly give us that much time to discuss these things. And if we have something on paper that we can show them, it would greatly help that discussion. And it's going to save us all time on the back end. So then we're not going to ask you for issues to be corrected after the fact.
So, Michael, before you move on, so I don't lose my train, different cities, different counties, different jurisdictions have different laws that allow their peace officers to identify and label a vehicle as abandoned for different things, not all the same. From the department's perspective, as long as it's labeled by a law enforcement officer as abandoned, we're not going to dig down into why or whether it was legal based on the city limits or the county, So you would have to tell us, hey, this agency labeled this vehicle as abandoned, but we don't think it meets the legal definition of abandoned under that municipal code or under that, so that Central can refer it to CED, and then we'll go look into it. Because if you think it's mistakenly identified as abandoned by law enforcement, like you said, you might not get them to listen to you. You tell us, we will.
Okay.
But as to whether or not the law enforcement agency was following the law when they labeled it as abandoned, we won't look into that unless you tell us, hey, we think there was an error. We will accept
Okay. Is there a time in the process during the processing of this vehicle that we should notify you of that? Or is that going to be at the conclusion of the women's sale?
I would say as soon as possible.
Okay.
Because remember, you're going to send that packet to Central Services. When they get it, if you notify them, they're going to ship it to CED. So just call us. You can call us as soon as you think. You can call us on scene. And I've been driving by, and you got an impound, and we'll stop out with NHP, and I've had the tow operator say, "Hey man, this guy he's gonna check abandoned. I don't think it's abandoned." And so CED's happy to have a conversation with the agency as soon as you let us know.
Well, right. And I expect that we want to have that conversation sooner than later.
Right.
To help all of us.
Yep.
And are we able to have the DMV compliance officers or investigators that come to our lot anyways? Would they be an appropriate DMV representative to discuss that with too? If we suspect the abandoned was mislabeled by law enforcement?
Yes. Yep.
Okay, great. I have a few other, kind of small things to point out for the record guide. In summary, I think all the tow operators here have had lien sale packets been rejected by DMV for whatever reason. I'll go briefly through some of the reasons I've had them rejected. That situation existed because the law enforcement form wasn't completed to the DMV's satisfaction.
Sorry, Michael. I understand what you're saying. I'm going to respond very quickly because we're very quickly running out of time. Number one, when you talk about repeat customers and the values of the vehicle, I'm going to remind you guys, the only purpose for this process is to compensate you for the money that you're owed for tow and storage. It is not designed for you to maximize the profit you can get or the fair market value of any vehicle that you can get. You are not entitled to any money over tow and storage liens. All of the excess proceeds are supposed to go back to the legal owner. So if you can get your tow and storage out of it, that's pretty much where your concern should essentially end. You're not designed. This system is not designed for you to profit off of maximizing the vehicle value.
I understand.
Yeah.
Oh, sorry.
The other thing is, yes, absolutely. I get it. We've seen those. If you have if law enforcement makes mistakes in various jurisdictions and you cannot get them to change it, let us know. CED can go in there and we can talk to them, and we can, if they won't change it and we know that they checked the wrong box and this other thing is actually true, we will attest to that and we will change it. But you got to get those to us, because remember, they go through Central, then they go to. We'll tell you very quickly, we have an outstanding leadership team in Central Services that I could not be happier with. We are working very closely with them than we've ever worked with in the past, and so we're pretty excited about what is possible in the future. We've had some laws passed that allow us to get more staffing and to hire more people. So I hope I'm optimistic when I tell you this, and I wouldn't tell you about it in a minute, that let us know and we'll fix it. We have the ability to do that.
Okay. I'll keep my comments brief again. I have one more question, and it's I think it relates to the tow car record guide still, and it's about junk certificates and when they're issued to tow operators. So as my understanding is, if the DMV issues a junk certificate on a vehicle to a tow operator, then that places the tow operator as one of the owners of the vehicle. Is that a correct statement?
Yes, it would be. I think your name would be titled, essentially titled in your name as junk, right? Yeah.
Mm-hmm. Yeah.
But that allows you to then sell it to a recycler and profit off of again, remember, this system's designed for you to be compensated for your owed tow and storage.
No, I totally understand that.
Yeah.
I just want to discuss and clarify the process.
Gotcha. Okay.
So if the tow operator receives the junk certificate before the lien letters are sent for that vehicle, are the tow operator still required to send out lien letters after the junk certificate has been issued to the tow operator?
I don't. That's a Central Services question that is outside of my scope, and I think we would probably take offline for Central.
I don't mind taking it offline,
Okay.
but I think that should be included in the tow and record guide, because right now I don't think I'm clear as to what the process needs to be.
Okay.
So either we do the noticing to get the junk certificate, or we get the junk certificate, and once that's been issued, because I don't think we can reverse it,
Right.
then noticing becomes moot.
Right.
Because I become the owner.
Yeah, I get it. Okay. Yeah, we'll find out from Central. Yeah.
Okay.
That's a good question, because once titles have been issued, what do you care about? You know, the department has
Especially-
spoken. Department said, "Hey, yeah, sure, you met the requirements. Here's your title." At that point, theoretically, you're off the.
It's right, because as my understanding is, I cannot release that junk vehicle to the public anymore.
Right.
So what would the point be anyways?
Right. Yeah. I agree.
Then we have one more person online, Vince, if you want to go ahead and unmute yourself and proceed with your comments. Ask you also to be a little bit brief.
Hi, how are you?
Good, thank you. Go ahead, proceed.
Can you hear me?
Yep.
I may have missed this. What determines a vehicle to be valued under 1,500 or over 1,500? And that's the first question. The second question is, DMV now going to be coming to the tow yards to do an appraisal to determine that?
Well, we already do that. I got a big staff of appraisers, although not enough, but I got a staff of appraisers that does go out to tow and records to do appraisals. Right now, my experts, they do a component inspection to determine whether the vehicle's worth over 500 or not. So theoretically, yes, they would be doing that. Again, if there's a question, is that accurate? 50 guys? Yeah. I mean, some, there are vehicles where you don't have a question necessarily, it's, those work well more than 15. But yes, if you have a question, my appraisers will come out, that's what they do.
Okay, well, then the other question is what determines it to be under 1,500 or over 1,500?
Well, the appraisal, right?
Well, before, when they've done appraisals, there are specific guidelines that determine whether a vehicle was either junk, under 500 or over 500. And now it's just the two, so I'm wondering, is there a specific guideline for that? You know, I know before it was, if a vehicle is 10 years or older, or 10 years and newer, it would be over 500. 10 years and older, it could be deemed under 500 if it was not currently registered, if there was something missing on it, you know, some specific guidelines. What are those specific guidelines?
So there are specific guidelines that my appraisers use to determine the value of a vehicle. That hasn't changed, the trigger amount has changed. The auction trigger amount is from 500.
So it's just a dollar amount that changed, so
Right.
the guidelines are still the same.
Right, yes,
Okay, got it.
thank you.
And on that note, how does that apply to garages and body shops?
Same thing, it applies exactly the same.
But the appraisers won't come out to garages or body shops.
I'm not sure that's true, but I'll talk to my appraisers, but if that's the case, then.
I talked to the supervisor up in the Reno area, I think his name was Mattis, and he's the supervisor of the appraisers, and he flat out refused to, he says he only does it for tow yards and records.
Yeah, I'll find out what the reasons for that are, but however they're doing it now is how they would continue to do it. That hasn't changed, it's just that the trigger amount for the auction has changed from 500 to 1,500. All right, we have to wrap it up. We are going to go to, we'll now proceed to agenda item 3, general public comment. Is there anyone who wishes to offer any general remarks? Just as a reminder, we will limit your time to 3 minutes because we've got 7 minutes left before we have to be done with the room. Anybody who would like to make public comment?
Objection to 3 minutes. It's publicly noticed for 5 minutes. NRS 233B, you stated that this is not a regulation-making meeting, yet you're introducing a new record and tow car guide, 130 pages of explanation on how to do things. I'd like to go back in time to September 22nd with a draft for proposed regulation, which is essentially the new law. I'm good with the new law. You will not explain what a third party is, but let's talk about the purpose of this law. The purpose of this law, according to this regulation, is so tows cannot profit. Let's go back some more in time. What has the DMV done to, quell people, stymie people? Well, you guys have issued citations. You had the NTA seize documents, seize paperwork. All at the same time, there's been a rash of these throughout northern Nevada, and there's a ding, ding, ding email where Calneva was impounding vehicles from their own property, but you guys didn't give them a citation. Julie Butler on Monday, April 18th, 2022, issued an email to remove the wrecker and tow car guide from their website. You may ask why they did this. According to Sean Seaver to JD Decker on Friday, April 15th, congratulations, Tax Kai. The wrecker and tow car guide, CED is having a difference of opinion with a customer. So you guys have a difference of opinion with a customer, so Julie wants it removed. So if you don't like what the law says, you just ignore it and change it and make your own. Then there's another email from JD Decker, Thursday, September 9th, 2021. Why we've been doing it wrong for 20 years. JD, you said that you were supposed to be issuing salvage titles for these vehicles all these years, and that's not what this email indicates. As a matter of fact, Ted Infield had a difference of opinion with you. And in your same email, why did you want to change the rules? Well, it says here, allowing tow operators to profit. I guess profit is a bad thing. You've recognized that before. I'd also like to object to the fact that I had to provide identification to come to this public meeting. You mentioned you don't want to violate people's Fourth Amendment rights is what you said up there shortly, but you violated my Fourth Amendment rights by making me provide identification to come to a public meeting. Thank you.
Thank you. Any other public comments? All right, let's see. The date is June 29th. The time is 4:54. If there's no one else who wishes to speak, I'll close the workshop. Before I will close the workshop, I want to express my gratitude for you all coming today, for listening to us, for discussing with us your concerns. I think this is the way this needs to go in the future. We want to know what's going on with you. We want to hear it from you. We want to be able to discuss this with you in a civil manner and without, being accused of corruption and violating your rights. So I really appreciate all of you guys being here and being online. And I think we would like to do this more often if it's beneficial to you. I promise you it's beneficial to us. Thank you. Thank you. And with that, thank you all for attending, and I will close the workshop. Thanks, Mark.